what's really left as far as the ability to sue the federal government, the state government for money damages are particular statutory provisions that take a couple of different forms. And these are all sort of exceptions that are generally very narrowly construed, just because, again, of this idea of the risk to the public fisc. The first of them is the Federal Tort Claims Act, which the casebook talks about. It allows suits for money damages due to the wrongful acts of government employees that have been acting within the scope of their employment. And this kind of amounts to a statute that allows government actors or government entities to be made vicariously liable for the behavior of their employees. Now, there are a lot of exemptions and exceptions within the scope of the Federal Tort Claims Act, which the casebook discusses, and if you're interested in taking a look at those, you can certainly look at the discussion that you can find at pages 609 to 610. The main things are that there are certain exemptions for types of intentional torts, and then there's this discretionary function exemption. It basically says that if the statute gives the government the ability to make sort of a discretionary call in a particular area, then the statute, the Federal Tort Claims Act, will not allow you to sue that individual for making that discretionary call. The assumption here is that there's some sort of a broader policy choice that's being made, and the considerations that are going into that broader policy choice by the government are considerations that presumably they're taking into account the risks of injuring individuals. And so as long as they're making decisions within the scope of the discretion that they've been given under the statute, we're not going to allow them to be sued for making a discretionary call that's taken into consideration all of these things, and then sort of ultimately making a decision that ends up hurting somebody. The place that they get in trouble is if they're not discretionary decisions. Okay, you government employees that are going to go out and build roads, go out and do it in a way that designs the road in the most appropriate manner. And they build it in a way which, without sort of intentionally trying to save money, they just build it badly. Big potholes open up in the middle of it, and there's big accidents as a result. That's the kind of thing that doesn't necessarily fit within the scope of the discretionary function exemption. Okay. The other sort of, I wanted to mention that there's an Oregon equivalent, the Oregon Tort Claims Act. This has actually been a big deal in the last couple of years because of an Oregon Supreme Court decision from the beginning of last year, I guess maybe the tail end of this year. Sorry, the tail end of last year, the beginning of this year. See why I'm not in there yet. In that decision, which was named Clark versus OHSU, the Oregon Supreme Court struck down a portion of the Oregon Tort Claims Act as it applied to private individuals who are working as employees of a state entity. And so the question there was doctors at OHSU. Now, OHSU is a governmental entity. As such, it's subject to sovereign immunity, and it doesn't cause any problems with respect to the provisions of the Oregon Constitution that were at issue in Clark. The problem is that the Oregon Constitution says that the legislature cannot basically infringe upon rights that were available at common law. The problem in the Oregon Tort Claims Act is that it provides basically that doctors who work for the state are basically immunized by the state for their actions. And the immunization includes not merely covering the defenses of the doctors, but it also includes the statutory caps that are part of the Oregon Tort Claims Act, because it's not a total waiver of sovereign immunity. There's statutory caps that are included within the scope of the Tort Claims Act. Now, because of that statutory cap, when these private doctors or these individual private actors are brought within the scope of the Oregon Tort Claims Act, they are subject to these statutory caps, and that was viewed by the court in Clark as being a situation in which the legislature was basically taking what would have been the ability to sue doctors for millions of dollars for malpractice under the common law rules and converting that by bringing the doctors within the scope of the Oregon Tort Claims Act into a limitation on the ability of individuals to sue. And the court said, the amounts, these statutory caps are not high enough to justify that kind of a limitation on what would have been a common law right to sue these doctors for malpractice. So the legislature went back last term, has tried to fix it by increasing the caps that are included within the Oregon Tort Claims Act. It remains to be seen whether that's going to ultimately make a difference on the statute or on the constitutional question or not. The other provisions that you can find in the statute are the federal or the other provisions for money damages, causes of action for money damages, are things like the Federal Tucker Act, which applies to what amounts to basically non-tort money damages. It provides a cause of action for non-tort money damages. So if you've got contract claims against the United States that aren't otherwise encompassed within the scope of a different federal statute, if you want to bring a takings claim against the United States and want to sue for just compensation under a takings claim, you would bring it under the Tucker Act. Those claims are brought in the Court of Federal Claims in Washington, D.C. and appealed directly to the Federal Circuit. There's other specific monetary acts. The other thing that I want to mention here are non-statutory causes of action. Since the APA and other causes of action are limited to particular agencies, particular remedies, and so forth, there are other mechanisms that you might try and use to bring a lawsuit against either a federal or a state agency. So some of the things that the casebook mentions that are available to you are things like injunctive or declaratory relief. Typically, a declaratory judgment act is going to be floating around out there under both state and federal law, and you might be able to use that as the basis for bringing a lawsuit against an agency that's not doing something that you believe that it should be doing under the law. Usually, these types of causes of action are precluded if there are other remedies that are out there. So usually, it's only available to you if you just can't get at that agency's action in some other way. Writs of mandamus are another mechanism. Mandamus is a traditional common law writ that is used to basically order a governmental actor to do something that it is obligated to do. Now, the trick with mandamus, and this is particularly true in the federal courts, is that it has to be a cause of action that is required. It's something that you can't go in and say, well, the agency had a choice to do a variety of different things, and it didn't choose that. Or it didn't approach it in the way that you wanted it to approach it. You have to be able to say that the agency was required to do X, it didn't do X, and now, court, I want you to order, through a writ of mandamus, the agency to do that thing. And that's the only appropriate mechanism for a mandamus writ. In the federal courts, they're almost impossible to get. It's very, very difficult to get a writ of mandamus in federal court. State courts are a little bit trickier, especially in Oregon. Oregon tends to use the writ of mandamus on a much more regular basis than is true in the federal courts, and it's more successful. I mean, those things obviously go hand in hand. So the availability of a writ of mandamus is something that's worth looking into in the context of Oregon administrative law procedures, maybe not as much in the federal context, although it's always worth thinking about. You never know. And it's certainly available. It's just not that common. The other thing that you might have available is habeas corpus, but that, of course, is only going to apply if you've got circumstances in which there's custody or confinement of somebody. If somebody is being held in custody or, excuse me, terms of confinement, you can challenge that through the process of habeas corpus. There are a lot of very specific rules that we're not going to get into here, but it's just a mechanism that's worth noting.